If you've been drowning in student loan debt and wondering if bankruptcy could finally give you relief, the answer is maybe. Student loans are one of the most misunderstood areas of bankruptcy law, but there are exceptions, and in today's video, I'll break it down for you. If you've read a headline that says, student loans can now be discharged in bankruptcy, wait a second. While the laws are slowly changing, most of what you see online is either outdated, misleading, or just plain wrong. In this video, I'll walk you through why it is still very difficult to discharge student loans and what you really need to know before you waste your time or money. Hi, I'm Lynda Saedi, and I'm the founder of Saedi Law Group and Reliance Legal Education. I've helped thousands of people get a fresh financial start through bankruptcy over the last 25 years. Today, we're tackling the complex but critical topic of student loan discharge in bankruptcy. What's possible, what's not, and what's changing. Let's start with what's all over the internet right now. Articles, TikToks, and Reddit claims claiming that student loans are now easy to discharge in bankruptcy. The truth? That's mostly clickbait. Yes, there have been some changes. Yes, some people have succeeded. But the process is still complex, expensive, and rare, especially if you don't understand how the law works or what judges are really looking for. This isn't a credit card. You can't just file and walk away from student debt. You have to take extra legal steps and meet a very, very high bar. So let's get started with the big question. Can student loans be wiped out in bankruptcy? In most cases, the answer is no, at least not automatically. Unlike credit cards or medical debt, student loans are treated differently under the law. They are considered non-dischargeable unless you can prove that repaying them would cause you undue hardship. That phrase, undue hardship, is the key, and it's not a simple one to prove. You don't just file bankruptcy and list your loans. You have to file a separate lawsuit within your bankruptcy case called an adversary proceeding, where you will ask the judge to make a special ruling. Here's why discharging student loans is still tough. Number one, they're not automatically discharged. You have to file an adversary, which is that lawsuit, to ask the judge to rule on your loans. Number two, the Bruner Test still rules. Most courts, including Georgia, use the Bruner Test to determine whether you qualify for a discharge. It requires that you prove you can't maintain a minimal standard of living if you repay, your financial situation is unlikely to change, and that you've made a good faith effort to repay. Number three, judges are cautious. Many judges are reluctant to discharge federal loans unless the borrower has exhausted every other option, including income-based repayment. Number four, loan types matter. Private loans are sometimes easier to challenge, but not always. And federal loans come with so many repayment options that court may say you don't qualify for undue hardship. So the standard used in most courts to decide whether you meet the undue hardship requirement, as we mentioned before, is called the Bruner Test, and that's what we use in Georgia. There are three parts to this test: the minimum standard of living, persistence of hardship, and the good faith effort to repay. This is a very high bar, but it's not impossible. Here in Georgia, judges do follow the Bruner Test, but how they interpret it can vary. They'll look at allowable household income and expenses, medical issues or disabilities, job prospects, and repayment efforts. Having an experienced bankruptcy attorney really makes a difference. That's exactly what we help our clients with here at Saedi Law Group. What has actually changed? Well, to be fair, there have been some improvements. The Department of Justice has issued new guidelines encouraging a more flexible review of student loan discharge cases. The SAVE program and other reforms have made federal loan repayment more manageable. Some courts are starting to ease the burden of proof just slightly, but these changes have not rewritten the bankruptcy code. The bankruptcy law has not changed. They've just slightly loosened the screws, so to speak. So let's talk about new relief outside of bankruptcy that may impact your student loan situation. The SAVE program, replacing repay, offers lower monthly payments, interest won't build up, and forgiveness after 10 to 20 years. The Department of Justice has also issued new guidelines making it easier to settle or discharge loans in bankruptcy. If you don't qualify for a discharge in bankruptcy, there's still options. You can defer or forbear, go into a forbearance. You can request an income-based repayment plan, or you can refinance your loans. There's really almost always a path forward. You just have to see what you qualify for. Student loan relief is not a one-size-fits-all. So whether you qualify for a discharge, or you need a strategy, or you need to know your rights, contact a bankruptcy attorney in your area so that you can find out where you fall. And I know a lot of people read blogs and forums and social media posts that totally oversimplify, or honestly, they just totally misstate the law. And here's what I've seen. People try to discharge loans without filing an adversary. Borrowers are thinking that federal loans are dischargeable because they heard about some one-off case in another state. TikTok lawyers are just saying, file bankruptcy and you're done. Don't fall for any of that. Bankruptcy law is very nuanced. Every single case is different. Every judge interprets facts differently. What worked for someone in California with medical issues might not work for you in Georgia with a steady income. Student loan relief is not impossible, but it's not as easy as the internet makes it. I would really recommend that you schedule a call with an attorney in your area to review your options, because again, bankruptcy law has not changed in terms of discharging debts. And one thing you'll see if you're one of our clients, we immediately disclose that to clients. Filing an adversary case can be very expensive. It will cost you thousands of dollars to do it because it's a trial. It's not just some willy-nilly motion that gets filed and that's it. It will be a trial. And shocker, the United States government usually is going to oppose you trying to get rid of any debt. And yes, we have discharged bankruptcy or student loans through bankruptcy, but these have been for people who are permanently disabled, who are elderly. They're never going to be able to work again at that income to repay it. But most of my clients have just hit a little bump, but they're able-bodied, they're able to work, and they're most certainly not below the poverty line. They may be struggling, but they're not below it. I got news for you. Right now, the way the law is written, it's going to be super, super hard to get rid of a student loan. But if you have questions and you think you may qualify for it, definitely schedule a call. And if not with me, with another attorney in your area that can review your options.